Thank you, Jenny. It's probably you now doing all that. All right, well, welcome everyone. You can see the agenda right here for our meeting today. Thank you so much. We're starting closer to time with a quorum. A little ironic how we don't maybe need the quorum today, and here we have it. But sure appreciate each one of you and all of our staff. So it is the date of March 17th, 2022. This is our Indigent Defense Commission meeting. And we don't have to read all those original things, but the anchor location, of course, is always the office in downtown Salt Lake for folks. And so the first thing on the agenda is our approval of minutes. Well, actually, let's go ahead and say who's here. I like to do that still because it's good for the public to always be aware. Let me try to get all the participants. Okay, here we go. We have staff, Jenny Bird, Leslie Howitt, Adam Troop. We have Deborah Nelson, Greg Bates, our executive director, Matt Barraza. And that's staff. So now commissioners, let's have you introduce yourselves. Michael Z.
Michael Zimmerman.
And you fill which position again that's
The
required?
Judicial Council has one appointment.
Yes.
So I'm the former judge appointee, I guess.
Yes. Very good. Wally.
Wally Bugden. I'm a private defense lawyer.
Great. Margaret.
Margaret Lindsay, Utah County Public Defender's Office and the Child Welfare Representative.
Great. Okay, Mary.
Mary Corporon, and I believe I'm here as the designee of the Utah Association of Criminal Defense Lawyers as an attorney in private practice.
Yes. And Ben also here with staff. Thank you, Ben. Heather.
Heather Schriever, Utah League of Cities and Towns.
Great. Let's see, Pam.
Pam Vickery, I am the juvenile delinquency representative.
Great. And then Rich.
My name's Rich Morrow. I'm the designee from, I think, full-time public defender agencies. I'm the executive director of the Salt Lake Legal Defender Association.
Very good. Sean.
Hello, Sean Milne. I represent a UAC appointment for counties of the 3rd through 6th class.
Very good. And Economic Development Director for Cache County, right?
Yes, ma'am.
Yep.
One of the best, and I'm
Yeah.
very humble.
It's a great county. It's a great county. And then let's see. Summing us all up, Tom.
I like to finish things up. Tom Ross, the Executive Director of CCJJ.
Very good. Thank you, Tom. Hope everyone's caught up on their sleep. And so we're going to first have our legislative recap and have Matt and Adam lead us in that. I think we have a lot of good news.
Matt, you want me to go ahead or do you?
Well, yeah, you go ahead, Adam. I did, soon after the session ended, send an email out, but Adam's going to go in some detail about the some of the laws directly related to IDC and some that, while not totally related, definitely affect indigent defense statewide.
So thanks. I'll go ahead with this. And I started with these four. These are 4 bills that we asked legislators to bring forward. In fact, one of them started before Joanna left. So I'm going to try in the next 20 or 15 minutes to summarize what happened in the last 45 days of ridiculous process and the 6 or so months before that. So we've got a lot that's been happening over the last few months, obviously, and a lot of this spreads back into the summer. The 4 that we started were these that you have in front of you. And the first one is one that Senator Weiler does every year for us and makes some minor changes to the law, and this is one that Joanna started. So Jenny's going to move these slides forward, and so I'll go to the next one quickly. These are available to if you want to go back and look at them, but I thought I'd put the text in. So this bill really was intended just to modify and expand on what we can define when giving grants out, what we can identify as defense resources. This came about in part because we had situations, in Duchesne County was one of them, but others can come up, where there's a need for or benefit for hiring or engaging another attorney to work on a complex case or to provide expertise to somebody who's relatively new. And so the idea that that an attorney contract was specifically excluded as a defense resource in the past was something we wanted to try to eliminate. So we tried to expand the list and instead simply decided we'd eliminate it. But as we have all been going through defense resources discussions for the last 5 and 6 years, I think we have a pretty good handle on where we can go and what the priority will be. So I don't think we needed that much guidance. The second piece is the bottom there, 7C. That is sort of, I call it the Lance Dean protection provision, since he is actually engaged or employed by the county. He is considered an indigent defense service provider because he is, even though he's employed, we just made that change to the statute. So relatively minor, but again, cleanup and clarification. Anybody have questions on that, thoughts? Okay, go to the next one if you would, Jenny. It's the text on this got a little bit messed up when we transferred it over from one format to another, but it's still pretty simple. This is a change the code that we wanted to make because we worked with the Appellate Rules Committee to make a similar change in the rules of appellate procedure relating to child welfare appeals. Under the old rules and under the current law, the trial attorney had to be the one to file the initial petition on appeal, which is a petition asking the court to let us appeal. And they had to stay on the case throughout the time that the appeal was running. The court's rules prohibited that because several years ago, there was a requirement, as many of you know, that an attorney who was going to file an appeal as appointed counsel had to be qualified and put on the roster, approved by the Court of Appeals for that specialty. So this law and that rule was directly in conflict with the rest of the appellate rules. And so we got that changed thanks to Margaret and a lot of other people helping. And Margaret and Kirsten Norman, we worked on that for quite a while with Deborah. Deborah helped us push it forward. I'm really pleased about that, but it made this change even easier. And it was nice to put the discussion in front of people. There was really not much argument that could be had. The portions that are bracketed are what has been removed. And you can see if you read that through, the idea was that under current practice, current law, the parent had to keep the court and the opposing parties and theoretically, well, court and the opposing parties informed about where they were after the termination of parental rights and what was going on while the appeal was pending. I don't think we require that in most other appeals, but we did modify it simply so the parent has to keep their counsel informed. It seemed like a reasonable modification. And the rest of it was modified to allow, or rather to allow the trial attorney to withdraw and make this consistent with the requirement that appellate counsel be qualified and on the roster. So that's that change, went through rather easily, and I'm happy to answer any questions if you have them. Okay, good. I'm pleased with this one. It took us a while to get that rule changed, but it's nice to have it in place. And having the appellate division in place to make this work is crucial. Otherwise, we have potential of real significant delays, but it's moving forward. And I don't know that Deborah's on the line, but if I can just put in this little bit of a plug to tell you what's going on. Since we started taking on child welfare appeals and having appellate attorneys who are qualified handle the petitions, which is the first step, we have had a huge rise in the percentage of cases that are accepted for full briefing. And Deborah or Ben, I'm not sure if you hear it, if you're there to answer, but the percentage is up something like 50% from where it was or more. That's been in the first 6 to 7 months. And so it's a long time to get to this point, but trial counsel is very happy to pass on their appeals, very happy to pass on the cases. And as I understand it, most have been really helpful in recognizing they should not be doing the appeal, and they're glad to get those issues for their clients to our division. So happy about that. Jenny, if you want to go to the next one then. This is another one. Senator Wayne Harper has been involved in child welfare issues and working on that legislation for years, since I started doing it. So I won't give a total number because it makes it seem like a long time ago, but he's been really helpful, really supportive on family rights side and on parents' interests. And so he was a good person to bring the idea of a pilot program for social workers in child welfare cases, and we called it an interdisciplinary team. I think we've talked about this before. They're used at different places around the country. The child welfare professionals on DCFS side have social workers who handle cases, manage cases, and work with the families. This is an obvious intent, is obviously to get people in place to help support parents on that side, help them find their way through complex systems, and provide expertise to lawyers who are trying to figure out how they handle the social work side of the job. So what he did was he gave us the requirement to create this pilot program. We already have social workers in place, but this is kind of a good thing to force us to create some structure, define what some of the outcomes we're looking for are, and then to build this over time into something that we can track through and see how to improve and how to use. This is only for child welfare. He also appropriated $170,000 for it specifically in the bill. That's what was awarded. It's ongoing money, and we will be able to hire at least a couple of workers with that money. But what we are finding is there's jurisdictions around the state who are adding these positions to their teams, to their legal teams, just on their own through several different mechanisms and funding options. And it's building into something. So we won't be working with just 2 people on this pilot project. We'll have a lot more to fold into it.
And I just want to say, Adam, I just remember, I think it was the very first commission meeting when I was brand new to this group. And I remember both Margaret and Pam talking about how helpful it is to have these caseworkers. And now I've learned so much about all the social work and the needs and human services and criminal justice. And it might just be like these people are also in short supply, right? But
yeah,
I'm so hopeful that this can become something all over the state.
Yeah, we are too, Lorraine. I think it's great. People like doing the work on this side. I think the folks who've come over to do it feel real gratified. For one, they have a lot less organizational expectation. They can freelance more on what they're doing, even though they're assigned to cases and specifically contracting with attorneys. It's less of an approval process, so it makes it easier to do the work.
Does this seem to go over well with the legislature, Adam?
It did. It really did. There's a lot of people who understand the concept, and they may not understand the differentiation between child welfare side and adult criminal, but they do get the idea. And it was easy to convince people the funding was necessary, and they like the general concept of what we're doing. And they like the fact that we're getting this done in rural areas too. So
good.
It's positive. Next one, please, Jenny. So this is something that came up at the end of the session, and I can let Matt weigh in a little bit more if he wants. Summary is pretty brief. It has to do with post-conviction in non-ag murder cases. And it is something there's been a committee worked on for a while. I think many of you know, if you practice in the area, obviously, that there is a need for people to do this work on some cases when the court believes an attorney should be appointed, but that's done almost always pro bono. The idea was to create this opportunity, this structure within our appellate division and then to put some small amount of money into it for right now to be able to fund that. This, because of the way it's written, applies in all counties, not just 3rd through 6th class counties. But the appellate division will take on the responsibility and will go forward from there. We expect it will build over time, and yet if we don't start now, we won't find out, and it's not much funding for now, but we'll expect it to build because there is a need, and this is a good way to fill it. Matt, if you want to give a little background, I think that'd be good too, because it happened pretty quick. And I will say before Matt starts, this is Matt's first bill ever getting passed. And for those of us who do this, it's a meaningful thing. So I'm impressed. It came up pretty quick and he got it through at the end of the session. Worried about some opposition, I was, but it got done.
Well, yes, that's right. As far as the speed goes, and that's all something that can be attributed to Senator Weiler and his expertise in getting bills pushed through as a priority. This bill really is a sea change in indigent defense in the state. These types of appeals are only allowed if somebody has either exhausted their appellate remedies or if they have missed their deadline for an appeal, but they still are raising some constitutional claims as a basis for the appeal. More often than not, they're related to ineffective assistance of counsel claims. Our appellate team is really eager to dig into these and to take these on. And I'll just share a little anecdote for those who weren't on the CCJJ meeting. We discussed this bill, and Commissioner Drexel was there representing the court. And typically, the court does not weigh in on policy-related bills, and so he needs to abstain from the votes. But on this bill, the court did weigh in, and they weighed in support, and he shocked everybody present because that was probably the first time that session that he was allowed to actually throw his support behind a bill. So if that's any indication of how important this is and how meaningful it'll be going forward.
Wow, that's cool. And yes, Commissioner Michael Drexel was able to join in just a tiny bit late. Michael, what do you want to say? And yay for you.
Well, I apologize for being late. My daughters asked me to take them snowboarding this morning, and I thought I can be back by 2. And so we went up and did some snowboarding, and then I was late.
That was a good choice. That was a very good choice.
It was beautiful at Brighton this morning.
Yes.
Yeah, this bill, I think, is a really big deal. The courts have struggled for a long time with having adequate representation for individuals who are pursuing post-conviction relief. And so it'll be interesting to embark on this together. And one of the training points that I'll be doing with judges, we'll have a legislative update about a month from now on April 15th, but I'll be saying we want to make sure that we don't, obviously inundate the IDC with so many requests that this becomes not useful. And so we want to try and work cooperatively and make sure that you get the most bang for the buck and that the right people are getting represented and in the right ways. And so it'll be an ongoing, I think, back and forth as we try to find the balance point. And if it's successful, I think we would join the IDC with future requests for additional funding to make sure that these sort of representative appointments can continue in the future. So.
And I'm often the one who's, the layperson trying to understand all this. But I wonder if this also includes where there has been new evidence because of new technology. Is that another time where this plays in?
Yeah, there's actually a bill from this session. Was it Senate Bill 210? I can't remember, but it talks about, no, it wasn't. It was a different bill, but in the post-conviction context that changed some of those dynamics. And I think that bill passed. Does anybody remember more concretely than me?
But it was a different bill. Yeah.
I think it was a different bill. Yeah.
Yeah, I can't remember. I have it vague in my mind too. But I'm not sure.
I have I mean, I've learned about a little bit about this from our county attorney, Troy Rawlings, who established one of those units, you know, and so that's kind of how I learned a little bit about it, and I thought it was really good. Thank you for adding and explaining about that.
Well, that's all I wanted to summarize with regard to what we took on specifically, but I do want to talk briefly about a couple of others that I did not put into a slide, but just wanted to give you some information on. Let me preface it by saying this too. I was just really impressed and pleased this year to see how much and how well we have people working together on defense side on these legislative issues. We had a big group of people who came together from different perspectives and met frequently, worked daily at the Capitol, and then worked daily remotely. And we had a set of great discussions about almost every bill, and it also gave us some real good direction on how to prioritize and where to go. And I see some of the people here, but I want to just point out that, you know, Pam and Rich work constantly on these things, and it's immensely helpful. I think Pam never stops working on it, as far as I can tell. She'd call me at 9 o'clock at night or first thing the next morning, and it's hugely helpful. We have a lot of crossover discussion, obviously, with the courts and with prosecution side too, but man, to have the opportunity to have such a great group of people, both practitioners and then political side legislative people come together is great. And I think we're getting some really good outcomes. So one of the things that did happen this year was a bill that passed. It wasn't council related specifically, but it was HB 171, which dealt with in custody interrogation of minors. And Pam started this bill out from discussions she had with people around the country, and just a general idea. And the concept was that police officers should not be allowed to lie to an individual, to a minor in custody, during an interrogation about either facts of the case or a promise of leniency if they cooperated. There was a lot of work that had to go into getting law enforcement, prosecution, defense side people together to talk about how to resolve that, how to come up with an agreed upon language, because it could have been a difficult fight. Pam worked really hard with a lot of other people, and I'm sure others in this group did too, but it was great to see that something meaningful came out of it. And it's good to see progress being made. It's good to be on the offense on juvenile justice issues, especially. So it was great. I loved all the work, and I know others did too. Tom mentioned that earlier today. There was a lot of people that had to get together to make that work out. So I want to hit that specifically. And Pam, if you wanted to say anything or follow up, that's great. But it's great to see us moving.
Pam, thank you. I just want to say that anytime I walked through certain parts of the Capitol when I was there for meetings, I think I saw Pam, and I started to realize certain people are always there. And it's so helpful. So go ahead, Pam. What do you want to say?
I just, Adam, you're so nice. Thank you. I just wanted to say Adam was so great through all of this. And also I just wanted to really thank Director Ross, because he was really, really helpful in getting, helping kind of frame some of the conversations and stuff like that. So I really just wanted to say how much I appreciated everyone involved, but specifically the two of them really on that issue.
It was a team effort, but you took the lead and you did the heavy lifting, and it was much appreciated. So thank you.
You know, this is just a great group of commissioners, and I think it's very helpful that Tom comes from law enforcement as in his position and with us. It's a great background that we don't always have in the mix of it, right? So, yeah, good.
Sorry, I'll try to wrap up quick. I don't want to take too much time on this unless people want to keep going. The other one that came forward that Pam pushed with a group of people also was SB 120. Senator Weiler brought that. It was intended to eliminate the imposition of fines and fees on juveniles through the court process and through the diversion process too, right? And it was It was a big battle. There was a big fiscal note that came out because fines and fees are used to actually fund some of the court's programs that benefit juveniles. So it's a bit of a challenge to figure out which way to go. But in the end, it was defeated because there were a few people in the legislature in important positions who didn't like the idea of eliminating fines and fees entirely. So it was pulled, which made a lot of sense in the end because there's a lot more that we want to have discussion about, I think, as a system. But from my perspective, there's a lot of things we don't really want to talk about because they're not that bad for the youth. And the more we talk about them, the more some people may want to make it worse. So I think I finally convinced Pam of that, but the discussion will be coming forward anyway in the next few months. So be aware of that. There's a lot of facets to it. Any question on that really quick or comment? Okay, then the last one I think is SB 231, which was preliminary hearing amendments. And this is something that, if I remember correctly, Rich and Mark Moffitt and Steve Burton initiated, and the three of them with Matt got together and started to try to push forward with legislative changes that would modify the preliminary hearing process to, as I understand it, actually make it a hearing process and make it productive. It's a big issue. I was really impressed they were able to get it drafted and get some language drafted through Senator Weiler. And it did get, the idea was presented in committee and he ended up not having it voted on or discussed in that committee because it was late in the process. And there were a number of prosecutors whose hair I actually saw on fire while they were in the Capitol. But that got calmed down, and I think they'll come back to it. A lot of discussion, but it was great to see those guys stepping out and saying, look, let's take on something that really has to be addressed, even though we know it's going to be a battle. So thanks for that. I look forward to more discussion on it as we go forward, and it will not be easy, but I understand it's got to be done. Something has to be done about it. That's all, unless any of you guys want to comment on that.
Madam Chair, if I might,
Yeah,
also,
yes.
there's a couple of other bills that I think will affect indigent defenders in the state. One is HB 148, which elevates a second offense DUI from a Class B misdemeanor to a Class A misdemeanor. And the way that will impact defenders, it will be really scheduling issues. That will mean that a Class A misdemeanor will mean the second offense DUIs where before they were filed in the Justice Court in most instances, where many of our defenders that we serve throughout the state have calendars. These will now be filed in the district court. And that's going to involve about 1,300 additional DUIs a year that will likely move from Justice Court to the district court. So how that may impact funding and what other people, how things unfold as the year goes on is a little bit unclear. There was, we tried to oppose that bill, but we didn't have much success, and I believe it passed. The second bill is HB 196, which is similar in nature in that it involves domestic violence assault cases, and it allows, I believe, either party to remove a case once it's set for trial in the Justice Court, automatically remove the case to the district court. And again, that has rather significant impacts on certainly institutional offices and then people that have contracts in justice courts that will now be required to litigate those cases in the district court. I know the courts have some concerns about that because it's likely to be a rather significant shift in resources from the justice court to the district court in those two areas of cases. And so, as a commission, those things probably ought to be on our radar screen as we evolve through the year and we listen to feedback that we're likely to get from defenders throughout the state.
What was the impetus behind that bill? Who was pushing that bill, Rich?
That was Representative Pitcher. And we had a number of discussions with her and expressed concerns. She was of the opinion that victims shouldn't be subject to two trials, one being in the justice court, a second trial being the de novo trial in the district court. We had a number of statistics that showed that there were very, very few there were some de novo appeals, not very many, but very, very few instances where people were subjected to going to trial twice. And so it was more of a victim right kind of thing where they didn't want to subject a person to 2 trials. And so the bill passed.
Yeah, and if I can say, at the courts, at the state court level, we're growing increasingly concerned about the number of things that the legislature is wanting to move from the justice courts to the district courts. This has some relevance for the IDC, I think, because as more and more work moves to the same number of judges, their calendars get longer, which creates delay across the broad spectrum of district court case matters, some of which are criminal cases and have serious constitutional rights. Obviously, I don't need to tell this group that are at play. But when you combine the number of new things the district courts were asked to do in this session, House Bill 196 with the transfer of domestic violence cases, House Bill 143 with the movement of cases for second offense DUIs, Senate Bill 53, where about 350 Class B misdemeanor speed contest violations are going to be moving to the district courts as Class A misdemeanors. And there's a number of other examples like this, plus the expungements of protective orders, plus the expungements of evictions. We don't have more judges. And so the calendars are going to get longer. And that's going to create delay across the entire broad spectrum of the state court system. And you layer on a backlog of a few years from pandemic operations and just increasingly concerned about our ability to deliver on people's speedy trial rights. So
Yeah. Boy,
that's positive news, right?
Yeah. I mean, thanks to both of you for bringing up these additional things. I remember hearing parts of this and to hear, how it all landed and kind of the consequences in from your perspective areas. It just, not everybody, especially what legislators have worked in these areas, and unintended consequences are for sure a thing, right? The only thing from my health and human services work that I thought of is the DUIs are really bad. And a lot in Davis County, Davis Behavioral Health established the first receiving center. Tom Ross was instrumental working with them toward that. And most people actually just need, if they will, treatment and the things, to kind of keep them out of a jail. So that's a big deal.
Can someone educate me or bring me up to speed on if there was any progress made dealing with the bail reformation process?
Yeah, and hang on.
Wasn't even touched.
Oh, wow. Wasn't even touched?
No, there's fatigue.
There's exhaustion. Yeah, that's what it was, fatigue.
And no new ideas. And so.
And I think the legislators who were involved in that were very clear with all of the stakeholders as we wound down that summer effort last year and had it pass in the special session. And that is, we're not doing anything with this until the dust settles. Like, we're passing this bill, House Bill 2003, in November at special session. And then we're just going to let people get accustomed to what we've passed. And then we'll see what needs to happen after we're all used to it. So no new movement there.
That's what I had heard also from our county attorney, and there was definitely fatigue. Yeah, good question, Wally. Tom, what were you going to say?
Yeah, I was just going to add on. Many of you probably already know this or were more directly involved, but for Matt and Adam both, this was an interesting session on the funding side, and things got really messy as it moved towards the second half of the session. And I thought they did an excellent job of meeting with legislator after legislator and strategizing. And as you've already heard from Adam, that there was a lot of collaboration with defense folks on this, on our commission and others. I got to say, from a overall criminal justice side, the collaboration between all groups was probably better than I've ever seen in some really big bills that came to consensus, 3 or 4 of them that took a lot of effort. But specifically for this group, I I just wanted you to know how well they represented IDC, and they were able to get the funding issues worked out, and just a lot of effort on their part. So kudos to them and for their leadership.
Thanks, Tom. It was an interesting few days there for sure. No doubt about it. For those of you who've done appropriations, you know what happens, right? When your number is there and then all of a sudden you're looking and think, wait, what the hell happened? Where did that go? And who has it, right? So anyway, but we got what we needed.
Gosh, yeah, a lot of work. And Commissioner Ryan Luce is here. Hey, Ryan, good to see you. Yeah, I even got into the Senate. Yay.
That's right.
But then I figured out that the very influential senator I was speaking with didn't really understand what I was sharing with him. Anyway.
Oh, well.
I'm his commissioner, and so I did get some time. Anyway.
Thank you. Appreciate the time.
Yeah, thank you. Anyone else who knew of something that we should all know about? How it all landed? So great discussion. Thanks for asking the questions and providing info. Thanks to everyone who worked so hard. It's a big, intense time for sure. All right, so Greg is going to give us the grant process update, and he has his own pile of work that he does a lot. Thanks, Greg.
Thanks, Madam Chair. I promise no spreadsheets today. Just a quick update.
Oh, hang on. Michael Zimmerman, did you have a question before we start this?
Well, my question, really goes to Mike Drexel. Are the courts doing anything overtly or covertly to address this this sort of campaign to put everything back in the district court?
No, we haven't, because a lot of these bills caught us off guard. So during the session, we started to take note of the number of things that were moving in the direction of the district courts, and it's going to be a topic of conversation. It's going to have to be. You wrap this up in some ways with, or you look at it in parallel with the Justice Court reforms that the Judicial Council has been recommending from the task force that studied this for a year and a half or so. And somewhere in between those reform efforts and what the legislature kind of did on an ad hoc basis is the right thing, I think, for the state at this point in time, as far as it relates to the division of cases between the district and justice courts. And it seems like the legislature might be trying to skin that same cat in a slightly different way, which is, you have concerns about de novo appeal? Okay, well then let's move those cases out of the court that requires there to be a de novo appeal. And maybe there's a better way to do this than doing it on an ad hoc basis by some more fundamental and structural reforms. And so we'll be talking with legislative leadership, I think, about some of those things to see if they're willing to stop pushing things into the district court on a case-by-case basis and look more holistically at what the division of cases ought to be.
Okay,
thank you. And, yeah, and related to that, I know this group and especially staff always desires to help educate our legislators, and particularly all those in leadership. And we talked about an effort for that in the interim. It gets so intense for those legislators, you know, when the fire hose is going on and even preceding that time. But the more that we can in the off season help them to understand some of the fundamentals, I think plenty of them would like to learn more. And hopefully we can make that progress. Not quite sure, you know, how we schedule that or do it, but I know Matt and Adam have both talked about that, and I think that will be a really good effort. So yeah. Oh, go ahead.
To Michael's question, or Michael's not question, his comments, I think you're right. And, you know, we saw a similar thing happening early in the session. There were, I think, 6, 7, and 8 bills that either had minimum mandatories or changed presumptions that increased penalties in statutorily instead of through, you know, the Sentencing Commission. And we ended up going in and having to go in, and we met with leadership in both sides saying, look, if this is done on a one-off case, one at a time significant change is going to occur in the criminal justice system. We're trying to improve JRI and fill gaps, and yet we may be swinging it more the other direction, and then incarceration is going to become an increasing issue. And fortunately, we were able to kind of pull those leadership help to kind of pull those together. And I thought the work that was done kept any of those from statutorily moving forward. And we were able to do it with the Sentencing Commission and subcommittee. So that's probably a similar thing that you guys are dealing with too. And we're going to probably see more of it as people try to find this right balance, trying to do the right things, but maybe it's not in the most effective way.
Great, thank you.
Thanks, everyone. Greg, go for it.
Thank you. So just a quick update. This week we wrapped up managing defender calls. So we completed 17 of these calls with managing defenders or system representatives across the state. On those calls, we did a review of the grant process and the timeline for that. Sought any feedback from the service providers in each system, and then discussed managing defender duties and the status of those with each of those systems. And now we're moving into the collaborative grant planning meetings. So at these meetings, we'll do a presentation on the system needs evaluation results from January, as well as the caseload survey responses that we received. We'll provide staffing estimates by specialty area to each system, and then let them know any areas of potential improvement that we identified in the evaluation, and provide a list of potential grant funding items or suggestions to them, and then have discussion on those potential grant funding items, and try to come to a consensus on what to expect in each application. So the next steps, we'll wrap up these collaborative meetings by April 6th, and we wanted to extend an invitation to all of you to attend any of those meetings that you would like to. We'll send out a schedule with the dates and times of those after this meeting today. Once those meetings have concluded, we'll go ahead and release the application to the systems on April 8th. Those will be due back to us by May 6th. We'll do a staff review and seek any clarification on items on those applications. We'll wrap that up by May 20th, get the review materials out to you all by the 25th of May, so that we can have the discussion and hopefully the final funding decisions made in early June. So just a quick update, and that's where we're at with that.
That looks really great. And I was just going to check. I hope people will look at their calendars and make sure that that's the June 2nd meeting, right? That you're saying we would take.
Yeah, on or about June 2nd, I believe.
Okay, and that's a Thursday, which today is a Thursday, so that's probably typical. However, I don't have it on my calendar yet, so perhaps our staff can help send that out, and we can all hopefully make sure we are free and save that time. I remember that takes a bit of time, huh? That's like a full 2-hour meeting. Yeah, that'd be great. Yeah, send out those calendar invites for these next ones coming up, and then we'll hopefully save it and be able to be right on at the top of the hour. Thank you. Any questions that anybody has about that? Okay, no, it sounds very straightforward, Greg. We've got some experience in this group now. Good work, Greg. Okay, let me get back to this agenda. Let's see, Matt Barraza, our executive director, share with us about managing defender duties.
Yes, I wanted to touch base with you all about a project that I'm going to be working on in the near term here. As Greg mentioned, as part of the grant process, we checked in with the managing defenders over the past couple of weeks, not only just to see how things were going in their different systems, but then also to check in with them on their duties as managing defenders and how that was going. And I think there was a broad range of responses. You know, some of them were very, very involved and very hands-on. Others were maybe not doing as much as we would have hoped as managing defenders. And so we rolled out about a year ago, staff put together the managing defender duty manual, and I can share the link to that here in the chat. And that was a very comprehensive list of what the IDC felt that the managing defenders should be doing as part of their job. And it was meant to be, at the time that it was rolled out, very aspirational. It was a new document. There was really no expectation that people would start doing all these things immediately. In fact, it said so pretty explicitly, like, you know, we know that people might not be able to do all of this right away, all at once. But now that people have been in these positions for as long as they have, I think it's a good time to start revisiting this document and these expectations with the managing defenders and try to elevate the management that's going on, both in a couple of different ways. Some of the managing defenders could use some help with data reporting and making sure that we have good information for the IDCs so that we can appropriately identify what the needs are and where those needs are. But then also to help their public defenders throughout the state to make sure that they have the resources they need, that they're getting the supervision that they need, that they are serving their clients in an effective way. And so to that end, we're going to be starting a monthly roundtable with the managing defenders starting next month. Our first topic is going to be performance evaluations. A lot of the managing defenders are not conducting any kind of performance evaluations with their attorneys. And a lot of the explanations that they had were that, well, I'm in court with them every day. You know, I know how they're doing. I can see how they're performing on a week-to-week basis, which is totally understandable. I mean, I've been in similar situations myself. But what we would like to do is to make this, rather than rather than it being a assessment of how people are performing as attorneys, but more of an opportunity to identify areas of growth, set goals, have some positive feedback and some positive reinforcement, and really establish a sense of common purpose amongst the attorneys throughout the state. So that's something that we're working on in the near term. I'm also going to be, I think it'll be helpful to revisit this manual and maybe make some changes and identify some of the priorities as far as these duties, because this is a very content heavy document, and I can see that it might be a little bit overwhelming for a managing defender to look at this and think like, oh, I'm supposed to do all of this, plus maybe carry a caseload myself. So I think it would be helpful to maybe restructure it and identify, simplify it a little bit, and make some expectations clear as to how we would like the managing defenders to start implementing some of these duties in a more structured way, and to follow up with them and to help them really and assist them to carry this out. And to that end, if there is anybody on the commission who would like to participate in these managing defender roundtables, or who would like to take a crack at the managing defender manual. I know that this is a very expert commission that we have here, and I would love to have some of that expertise as we take this next step with the managing defenders. So I will be sending out an email myself requesting any volunteers who would be interested in doing that. And then I know that some of the people here today have very robust and tried and true performance evaluation practices themselves with their firms and attorneys. So if they'd be willing to share some of their evaluation forms that they use, their annual review forms, I'd like to take that to this roundtable that we're going to be having to distribute it amongst the managing defenders, and we can take a look at that and see what's going to work for those defenders in their different systems, if they want to take some of those and tweak them and customize them so that it'll be more tailored to what they're doing. I think that'd be really helpful as well.
That's great, Matt, thanks. Hi, go ahead, Wally.
Last year, I talked about performance evaluations, and I don't really have any personal experience with it because I've been in private practice. But I think it's going to be very, very tough for me. I guess before I say what I want to say, I'd be really interested to hear what Pam has to say and what Rich has to say, or Matt. You would sit in on performance evaluations, or you would evaluate, I guess, some of the lawyers you were supervising. I think it's a very tough thing for people to be able to be, even though it's intended to be constructive criticism, I think it's a very difficult thing to do in a forceful way if a lawyer is not really stepping up and doing a good job. And the only way, with Rich, for example, Rich is out of the loop. He's not seeing people in court anymore. So he has to rely on Matt. You were one of the supervisors. I mean, didn't you find it to be pretty tough with the people that you were the supervisor of to be critical of them? Or
well, and the way that we did it at LDA, it wasn't a very critical. I mean, it was a very positive experience, really. I mean, it was every year, it was once a year we had this time designated to talk about goals, areas, it would be on the attorney to provide a list of things that we would start out with successes, things that they want to brag about, basically, that happened over the past year. That could be, trial specific or case specific, maybe training that they received over the year that they wanted to bring up. And then that would shift into areas that attorney felt that he or she would like to improve on, right? So it wasn't really a top-down, this is what I've seen that you need to change. It was more of a bottom-up reflection on the past year and the year going forward. And so that was never something that I felt any kind of, fear or trepidation going into, because it was structured in a way that was very, very positive. And then, the following year you could follow up and see how those goals were going and tweak those goals or make new goals. And so that was something that, going through these managing defender check-ins that we did, we would ask, are you doing these performance evaluations? And I think that there was just a lack of information on the part of the managing defenders that what exactly was what we were asking with that question, and I think a lot of them thought it was more of a, okay, we're going to call you out for X, Y, and Z, when in fact it could be something that's really a positive experience and should be a positive experience.
Sorry, I was a little slow unmuting. Yeah, I agree with what you just said. It should be a positive experience, a time taken to appreciate people's work and to jointly help people develop, right? Yeah, Tom, I think you were next. What would you like to say?
Yeah, I'm supportive of that, of the concept of it, but I also understand what Wally's saying. And I think what's important here, and just from conversations that we've had within CCJJ that Matt and Adam and others have been a part of, is there's different ways of evaluating people. Coming from the law enforcement side, there's a lot of numbering systems, and they're very specific and I think overburdening for most individuals that need to be evaluated. But I think that where this could be a strong positive is certainly in the area of, as Matt said, of trying to move things forward and being able to somewhat ensure that everything's being done. I mean, I remember with Duchesne, that whole issue we went through, and part of their accusation or allegations that the time wasn't being put in, you know, and that the attorney that was providing the services wasn't putting, you know, they were billing maybe for time they weren't. I think it helps in protecting against that. If you're asking for more money, and certainly at some point there'll be pay increases that should be part of the conversation, I think it's almost a necessity to help support that. That's something the state's trying to find a better way to recognize performance in many ways, because they're paying below the level of other governments. So they're trying to find ways to improve that. But I do think it ought to be simple. I don't think it needs to be a complicated scoring system in a way to get input from the attorneys, as well as for Matt and or Adam or others to give direction in a positive way.
Thank you. I think, Rich, you were next.
Yeah, no, it's, you know, to Wally's point, it is a little tricky when you do those things. I mean, you know, Matt will tell you, I think that what we try to do is we try to encourage ongoing communication between our leadership team, Matt being one of them, and lawyers that are on his team. You know, there are some structural changes that we're trying to make. We thus far have really very much resisted this idea of paying for performance, because I think it's really hard within the criminal defense context to decide how you evaluate performance, because people are so different in the way that they perform. Some people are really good at sort of getting plea bargains and don't try a lot of cases. Some people try a lot of cases. That's why we try to encourage this ongoing communication. My role in the process is to frequently meet with the leadership team to try to get an idea of where there are problems early on, if there are problems, or what things are going well. And my yearly discussion, what I have is a yearly discussion, because if there are issues or problems, leadership, the people that lead their teams have hopefully addressed those early in the stage, number one. By the time they get to me, I just want to talk about how they're doing, how their development is. The other thing we rely very heavily on our leadership team to do is attorney development and the work that they do. But, you know, to your point, Wally, you're right. It's pretty hard to, you know, and the county has said to us several times, well, we'd like you to sort of structure some of your raises based on performance. And the idea that we sell back to them is, if we have people that aren't performing the way they need to be, we address those issues pretty early. But we really, oftentimes they don't end up in an evaluation, simply because we need to have that discussion so that people can change what they're doing. And if you do it early enough and you have communication and you have open lines of communication, it should take care of itself. But there are complexities to it, so.
Pam, would you talk about that for just a minute? I'm just really interested in how you give feedback to the lawyers, or is it more that the lawyers are giving you the management feedback? What's your experience, Pam?
So we do a yearly one, and what happens is we send the attorney a self-evaluation form that kind of, it goes along with what Matt says, right? Like what are your strengths over the year, your accomplishments? What do you see like as weaknesses and things like that? And then we have, as the supervisors, we have a really, it's kind of overkill. We have a really long one that goes through and talks about like all the things kind of that we think are important. Like we talk about, do you really make sure that you're doing expressed interest? And then we kind of go through, do you make sure to raise these types of things at court and stuff like that? And then we use defender data to track a lot of what the attorney is doing, like how many hours are they spending in which capacities? Not really that we care how many hours you're spending exactly, but so that we can talk about, like, it looks like, you know, because you can see, like to Rich's point, right? Like you're going to have some people that are get really great plea bargains and rock dispositions and stuff like that. But you do want to see that people do spend time like doing research or preparations on motions, or that they do have some trials and things like that. So we do it from that perspective. But I do agree. And then we also make sure to do court observation, which of course is easier because we're so much smaller than like Rich's office, right? But I think that what is really helpful about it is exactly what Matt and Rich said, is that while we go through a pretty lengthy process with the attorney about like what kinds of things they're doing in court, and I've shared our form, I think, like with Lance and some of the other managing defenders before, but it really becomes a process of the attorney feeling like they're supported and like they can talk and say, this is what I need, this is what would help me. And we always end with, okay, what can we do to be helpful and supportive of you? And let's set 3 goals for you that over the next year. And one of those goals always includes like some type of assistance from us, like whether it's you want a specific type of CLE, or you'd like to broaden your practice by participating on boards or things like that, or so really, I think it becomes something that the attorneys feel like, this is my opportunity to come in and talk about me and how I feel about my job and stuff like that. So they're time consuming, and they take a lot of work and stuff like that. But I think they're almost always positive in the end.
Okay, thank you. That was helpful for me.
Hey, Wally, if it's any consolation, what I ask all of our employees too is to also critique me, because I want to know what they think that I'm doing that's wrong, or that I can do better. And so sometimes that's a little painful, but it's really useful and helpful if you can get people to be honest about what they see in you and what they would like to see improved. So, I think it's a two-way street. We have to be willing to sort of understand where they're coming from and meet them there, but they also have to have, hopefully, feel open enough to be able to express those critiques that they may have also.
If only Putin had that approach to his staff, his management staff, if they were only giving him a little bit more feedback.
Yeah, and didn't have to fear for their lives. Yep. Pam's cute. I try never to invite criticism from myself. But I bet though, Pam, that you pick up on things and are always being a great leader. Let's see. Sean, you didn't unmute, did you? Were you trying to say something? No?
Oh, shoot. No, I didn't realize I was unmuted. Sorry, I just logged back in after getting disconnected.
Yeah.
Sorry about that.
No problem. And I can see that Katrina's with us too, but it says Jenny Bird for some reason. I don't know. And I hopefully introduced Jenny in the beginning. Yeah, this is an amazing discussion. Anyone else have something to add? I mean, I want to add that I love the idea of the Managing Defender Roundtable. I believe some of the very best things happen when, and I approve of it in our county, when we bring people together to the table and people help each other. I think that sounds really neat. I think it will help our managing defender in our county. Good. Those sound like some great initiatives.
Lorraine, can I just say something?
Yeah.
Sorry, I just was going to say, there is a man that you guys might have mentioned this. I had to take a phone call really fast, but there is also that managing defender listserv, and it doesn't get a ton of traction, not traction, but a ton of stuff on it, but it does have stuff every once in a while. And I actually really like that. Like we had some stuff about how things are proceeding with detention based on some of the changes in law and stuff like that. And I felt like that was a really quick, easy way to communicate and hope that it trickles down to line people. So I think it's a tool that is, anyway, I was just gonna say, I was gonna tell the IDC folks that I like that.
Yeah, I've heard you mention that listserv before. What a great support for your colleagues all around, huh? Keeping up with things. Okay, very good. Matt, did you get the feedback and interaction you wanted? I think that was really good.
Yeah, no, that was some really great comments, great discussion, and I look forward to working with anybody who's interested in participating in this going forward.
Yeah, so when you send that email, I'll just put the plug in. I mean, some of you have obviously some really good input. So yeah, Rich has to go. That's fine, Rich. But then when you leave, we'll volunteer you to be on this committee. Okay. Yeah, so some of you, I mean, I don't think it would take much time, but I think that these will be very good things. Great, okay. So we are just about done. Actually, other business, I can't think of anything. I already said that it'll be great to strive to put out the calendar invites for all of the meetings for the foreseeable future. My calendar just gets packed, and so I definitely prioritize and will save the IDC dates as much as possible. If you can send invites, sometimes too, if you can embed some of the materials within the invite. I probably couldn't duplicate it myself, but I know it's possible and my staff does it, and that's really helpful. Then I don't have to search for emails. Now, public comment. So if there's anyone who has found this meeting and would like to make public comment, we'd love to hear it. Oh, Jenny, thanks. We'll do that. We need to still approve the minutes. We'll do that before we drop off. Any public comment though? I'm not seeing anyone that we don't typically have for staff and commissioners. And let's see. Okay, so the minutes. They were sent probably in an email, right, Jenny, that had all the attachments.
Yes, I can send it again really fast. That's at the top of your email.
That'd be great.
Madam Chair, are you looking for a motion to approve?
Yes, if you've had a chance to look at them and they look accurate, Sean, go right ahead.
I did, and I would make such a motion to approve.
Fantastic.
This is Tom, and I'll second it.
Very good. And I had looked over them too, but it was a while back. Seems like a long time because my days just fly. So they looked really good to me. Is there anyone opposed to the motion to approve? Looks like everyone's good with them. Thank you for some great minutes. Okay, so let's see. I think we're just, maybe I got away from the agenda again. Here we go. So the next commission meeting will be April 21st. That's at 2 o'clock. I'm gonna look at that. Yeah, still really great for me. Hopefully that'll be a good time for folks, and hopefully by then we'll continue having periodic rains. Still some good skiing up high, I hope, Michael. Pray for the Great Salt Lake and all the birds, everyone that's up here. And thank you so much for your service on this great commission, and thank you, staff. Really good meeting. Oh, I need a motion to adjourn, I guess. Tom, are you ready to give that motion?
I will make the motion to adjourn.
Second,
Second by, who is that?
Michael Zimmerman.
Michael. All right. Thanks, everyone. Have a
Thank you,
great
everyone.
day.
See ya.
Bye.
Goodbye,
Thank you.
thank you.